A Supreme Court without limits would be dangerous. So Hamilton, built the limits into the Constitution itself. Hamilton ends his discussion of the federal judiciary by answering three big questions or three big public fears. And that is, will the Supreme Court be too powerful? Can Congress shape the structure of the courts? And can states still be sued? And does that destroy their sovereignty? And his answer in each case is measured and it's rather structured. The judiciary is strong enough to protect the Constitution, but limited enough to protect the people. So as we set the stage here for number 81, it explains how Article 3 creates a flexible judicial system, where you have a Supreme Court that is guaranteed lower federal courts that may be created by Congress, and they can design, expand, or reorganize these courts over time. And Hamilton reassures the public that the judiciary won't just grow uncontrollably. It grows only if Congress decides to grow it. And his main claim is the judicial branch is powerful in judgment, but it's limited in scope. And its structure gives both the nation and Congress the ability to control it responsibly. And Hamilton emphasizes that no branch is unchecked, and courts interpret, but they can't enforce, and their power is tied to the Constitution. Congress controls their structure and jurisdiction with limits, and this makes the judiciary both independent and contained. Now, will the Supreme Court become too powerful? Well, Hamilton argues no, because courts can only act when cases are brought to them. They cannot write laws, and they cannot enforce laws, and they cannot act on their own initiative. Their power is reactive, not proactive. So the court's supremacy comes from its role as final interpreter of the Constitution, not from any control over the other branches. And Hamilton describes judicial authority as judgment, not force nor will. And that limits the court by its very nature. So, why does Congress control lower courts? Well, Hamilton highlights a major feature, and that's a lot of Americans, they overlook this. And that is Congress can create, organize, or even abolish lower federal courts. This means the judiciary cannot expand itself. The structure is adjustable as the country grows, and Congress can prevent judicial overreach. The system remains flexible and responsive. Now, the Supreme Court is permanent. Everything underneath it is optional and adjustable. This gives the people, through Congress, a direct way to shape the federal court system. Now, the third issue, the Supreme Court's review of state courts. Now, there were some that feared that allowing appeals from state courts to the Supreme Court would destroy state sovereignty. And Hamilton counters that the Supreme Court is only reviewing the federal question, not overruling every act of a state court. If the case revolves around the Constitution, federal law, treaties, or national interests, the federal court must have final authority. Otherwise, states could ignore federal law, and the Constitution would mean something different everywhere. The Union would unravel, and supremacy in federal matters, it does not negate the state's own judicial authority in matters that are purely local. Now, issue 4, can states be sued? This was one of the biggest concerns of anti-federalists, and Hamilton explains that governments can be sued only when the law allows it. The Constitution does not automatically strip states of immunity, and the United States may create laws where states can be sued, but this is a matter of legislative decision and not judicial aggression. Hamilton insists the judiciary is not a wrecking ball aimed at state sovereignty. It follows the rules Congress establishes. Now, on a modern note, the 11th Amendment was passed shortly after ratification, and it reaffirmed this principle. Now, Hamilton's logic here, his chain of reasoning, his 6 easy steps in this particular essay, is that 1, the judiciary exercises judgment, not force. And then 2, the Supreme Court's power is limited by cases brought before it. The third point is Congress controls the creation and structure of lower courts. 4 is that Supreme Court review ensures uniform interpretation of federal law. 5, state sovereignty is reserved except in federal matters. And the system is flexible and adjustable as the nation grows. And that's your 6 reasons why. Hamilton's tone is more confident and reassured in this particular essay because he knows the public fears centralized power. So he emphasizes judicial limitation, congressional oversight, state level autonomy, congressional, constitutional supremacy, long term adaptability. And this essay brings closure to Hamilton's vision of the federal judiciary, strong where it needs to be, limited where it must be. Our takeaways today are that the Supreme Court is powerful in interpretation, but limited in action. 2, Congress controls the size and structure of the federal judiciary. And 3, federal courts ensure one constitutional standard while preserving state sovereignty in local matters. When we look at 81, it concludes Hamilton's series on the federal judiciary by showing how the system protects national unity, constitutional supremacy, judicial independence, state dignity, and democratic oversight. It's a judicial system that's designed to last, one that can expand, contract, or adapt without losing its constitutional backbone. And Hamilton believed the judiciary would succeed because it was both independent and firmly tied to the will of the people through Congress. And, it's more than 200 years later, and his design still influences American justice. In this episode, if you helped you visualize the federal courts, how they fit together and such, hang around. We're going to go on to Federalist number 82. And this is where Hamilton's going to start talking about state courts, but how the state courts and the federal courts coexist together. Thanks for watching.